In this video, ladies and gentlemen, we are basically going to be looking at transmission of land. We are basically going to be looking at how land is able to move from the names of, for example, a deceased person into the names of either an administrator or someone who has letters of administration, or into the names of an executor before it finally moves into the names of the beneficiary. So just for purposes of putting our discussion under context, normally the common scenario here that happens is you find that someone has died, and of course when someone dies, if they leave property, that property must be taken on for purposes of continuity. So here what we are going to look at is how does that property of the deceased move from the names of the deceased into the names of the beneficiaries. Now, there are two scenarios here. The deceased may either have left a will, and in that will he can name someone who should be able to administer the estate. Now, if that is the position, then that means that there is an executor. So that executor would have to apply for probate and then go on to distribute the estate. That is if a will has been left. But it is also possible that a deceased can pass on without leaving a will. So if there is no will, then an administrator to the estate has to be chosen. And of course, that administrator will have to acquire letters of administration and use those letters of administration to administer the estate. So here what we are looking at under transmission of land is how does that land move from the names of the deceased into the names of the beneficiaries. Now that is the whole process that we are going to be looking at under transmission. So basically we are going to discuss the practical steps. What are those steps? The systematic steps or the procedure that a proposed person for probate or maybe letters of administration, as earlier defined, should take in order to change ownership of a deceased person's land into their names, of course, before they finally now transfer it into the names of the beneficiary. Now, important to note from the word go is that in case someone has died and they haven't left a will, then of course the principle, as was clearly held down in the case of Best Kemigisha versus Mebo Komuntale, this is HCCS number 5 of 1998, that the general rule is that a surviving spouse has the first priority in applying for letters of administration or probate. So assuming that there are two married persons and either the wife or husband has passed on, the other surviving spouse always has priority to apply for letters of administration or probate. So, but it can also be possible that by the time the deceased has died, maybe it was, if there were two married persons, maybe the man who died or the husband was the last surviving person. Okay, so as Ali explained, then we'd have to look and see whether there is a will, and if there is no will, then we proceed to get letters of administration. So as we always do in our classes, I'll first share with you the position of the law, and basically I would encourage you to look at section 25 of the Succession Act Cap 162, and basically that section provides that all property devolves upon the personal representative of the deceased who holds that property in trust of the beneficiaries. So meaning that if that property comes into the names of the administrator, okay, or the party who has the letters of administration, or even the executor, that property does not become the property of that person, but he simply holds it in trust so that he is able to pass it on to the beneficiaries as provided for under the will. So the process or the practical steps or the procedure that a proposed person for probate or letters of administration must take has clearly been provided for under the law. So I encourage you to read under section 134 of the Registration of Titles Act Cap 230. It provides for that procedure. And please also go and read the case of Nabanoba. It's very authoritative. Nabanoba Desirant and another versus Kayua Joseph and another. It is CS number 497 of 2005. So those two authorities clearly lay down the process or the practical steps that have to be taken, which basically include the following. So the first step always is that the applicant, and of course, as we say, the applicant can either be the executor, or it can also be the person who is having the letters of administration, or the proposed person for that matter. So that applicant must first obtain an office copy of probate. Of course, probate is acquired if the will specifically appoints a certain person. That's when we proceed to apply for probate. So the applicant must first obtain an office copy of probate of the will or letters of administration. Now, that means that the applicant must have petitioned the competent court, of course, for the grant of probate or letters of administration. And the same must have been granted before the applicant can proceed or go on to the land registry to have the deceased land transferred into his or her names. So always the first step is to apply for an office copy of probate or of the will or the letters of administration. Authority for that position, it was already shared with you, but most importantly, please, I invite you to look at section 235, subsection 1 of the Succession Act, cap 162, which basically gives the High Court and these magistrate courts power to grant probate and letters of administration. So you either apply to the High Court or to the Chief Magistrate Court for purposes of getting probate or letters of administration. Also, section 242, subsection 1 of the Succession Act is also authoritative because it provides that probate or letters of administration have effect over all property and the estate of the deceased, meaning that the moment someone gets these letters of administration or probate, they get powers to control all the property that the deceased left behind. That is the import of section 242, subsection 1. So basically, that's the first step that has to be taken. The second step is the applicant, of course, must present that probate or letters of administration to the registrar, together with an application, okay, to change the current ownership of the land from the deceased into his names. So basically, he puts in an application, and that application, as we will see later, it is by way of ordinary letter. Okay, so you write an ordinary letter requesting that the registrar, of course, changes the names from, the names on the title from the names of the deceased into your own personal names as an executor or administrator. So basically, that's the second step. Let's now proceed to look at the third step. And basically, the third step is that the registrar has now to proceed and enter into the register book, and on the duplicate certificate, a memorandum notifying the appointment of the executor or administrator. So it will be entered on the title, notifying that an administrator or executor has been appointed. It will be indicated clearly on the will. Please look at section 46, subsection 2 of the RTA. It's authoritative, and it provides in essence that every instrument affecting land shall be deemed registered when a memorial of the instrument has been entered into the registrar or the register book. So basically, that's those are the procedures, or those are the steps that have to be taken. But also of essence, what you have to note is that upon entry being made, as we have discussed above, the executor or administrator becomes the transferee, okay, and is deemed the proprietor of that land or such part as remains unadministered. That's the position of the law. Please look at section 91 of the RTA. In essence, what this means is that the moment his name is entered on the certificate, on the land title, then it is deemed that he's the proprietor. Okay, he's the owner, or that property is in his names, not for his own use or for him to sell for his benefit. So he doesn't hold the property for his own benefit. It doesn't become his per se, but he simply holds it in trust for purposes of redistributing it or giving it to the beneficiaries under the will, or as agreed by the family of the deceased. Again, please make sure you go and look at that case of Naba Novandanatha versus Kayuandanatha, which I shared with you. But most importantly, what I wanted to pick out for you in that case are three holdings by court. And the first one basically is what I earlier discussed for you. Court held that a registration of one as proprietor to land before being appointed as an administrator or with no probate is illegal and fraudulent. So meaning that the position of the law is that the moment you're registered on land, okay, if a land title is registered in the names of an administrator or executor without them getting probate or letters of administration, that amounts to fraud, okay, and it is an illegality, and we do not accept it. Okay, it is an illegality. So the first step always is to get probate or letters of administration, and after getting them, you then proceed to apply to the registrar of lands to ensure that the land is moved from the names of the deceased into your names. That is the position of the law, and we are very strict on this. Also, the second holding in that case, which is of importance to you, is that the duty of the administrator or executor, as Ali already discussed, is to hold land in trust of its beneficiaries. So the administrator does not get ownership, okay, to this land for purposes of him to sell it and celebrate, and it doesn't become part of his personal estate, but he simply holds it in trust for the beneficiaries under the will or as agreed by the family. Then finally, also in that case, court was able to hold that the transfer into the executor or administrator's names doesn't mean that the land necessarily devolves upon the personal estate of the executor or administrator. I had already emphasized this, but just to add authority to that position. So basically, those are the steps and those are the laws governing how land is able to be transmitted from the names of the deceased person into the names of either the executor or the administrator. So let's conclude with the necessary documents. So in this whole process, what documents would you need? Of course, the first document, as we already saw, you write a request letter for registration of the applicant's names as the executor or administrator. And we said this request letter is by way of ordinary letter. Of course, the accompanying documents include a duplicate certificate of title, then also authentic letters of administration. You make copies or probate in the premises. 2 passport photos are also important. Receipts, of course, showing payment of registration fees, and also the information of the executor or administrator, such as a photocopy of the national ID, would also be of essence in the premises. So once again, thank you very much. It was really nice having you. We meet in another class, and please ensure that you subscribe to my channel. This is very important for you, so that every time we release videos, this is brought to your attention. And also, finally and most importantly, for students interested in private law tutorial sessions from the experts, if you're struggling, if you need some help, please contact us. We can always make private arrangements with you, and we will be able to help you so that you're able to succeed in your legal career. Contact us. Our numbers are down in the description box. Just pick it and then call us. We can always make private arrangements. Please don't forget to subscribe. Also turn on the notification bell so that every time I release videos, this is brought to your attention. If you're using your mobile phone, do not forget you have to turn it into landscape mode so that you can see the subscription button in the lower right hand corner. Thank you very much. We meet in another class. Bye-bye.